matter of Lodge Flats Ltd and Malik and others.
May it please your lordships, lady.
Yes, Mr. Latham.
I play for the applicant in this matter, my learned friend, Mr.
Could you speak up a bit, please?
Of course. My learned friend, Mr. James Kinman, appears for the respondent.
Yes.
As your lordship knows, perhaps just one point of housekeeping I should mention at the beginning. There is an appeal bundle. There is also what is said to be an unagreed supplemental bundle.
Yeah.
No issue with the supplemental bundle.
No issue, did you say?
No issue with that. I'm taking instruction.
Right, so we should admit it, should we? Right, we'll do that. When you get to draft up an order, make sure that's included.
Yes, indeed. Your Lordship, this is my appeal from the order of Mr. Justice Meade, dated the 17th of May, making no order for costs. That followed our success in appeal before him, in appealing 3 orders of the County Court made by His Honour Judge Gerald, the 14th of May order, the 19th of June, and the 23rd of June orders, which I'll come to. The sealed order under appeal, for your Lordship's note, is at Divider 6, page 49 to 50. Don't take the court to it at this stage unless there's any particular
No,
reason.
we've looked at the order, we've looked at the judge's cost ruling and his substantive judgment,
Lordship,
and the discussion about costs in the transcript,
Lordship,
and the skeleton arguments, of course.
Lordship,
Apart
yes.
from a supplemental skeleton, which I've only just seen.
Your Lordship, that is also in the supplemental bundle. I brought that in case there was going to be any issue over the supplemental
Right.
bundle, but that can be found there. That is the supplemental skeleton from, obviously from below, and I was going to take your Lordship's.
Oh, I see
in a
that.
moment.
Oh, I
It's
see.
got something
Yes.
to be, a sort of supplemental skeleton for today's purposes. Lordship.
Right.
It's from
All right.
below.
So that was in front of Mr. Justice Meade.
It was indeed, yes.
Yeah.
Lordship.
All right.
Your Lordship, so far as the underlying factual background is concerned, that is comprehensively set out in the first 26 paragraphs
Yes.
of Mr. Justice Meade's
Yes.
judgment, so I wasn't going to take you to that. It seemed to me...
No, it's a horrible family dispute.
over a property in Knightsbridge. So, yes, that's right. It seemed to me that the relevant substantive background was actually the shape of the proceeding, of the appeal before Mr. Justice Meade. I was going to take you through as quickly as I can, whilst informing the court sufficiently, looking at the appeal, that material, which in my submission comprises the appeal notice and the skeleton argument, then to look at the respondent skeleton argument, then to look at the supplemental skeleton argument, so the court can see the scope of the arguments that then going into the appeal hearing, and then to look at the transcript and briefly the judgment, which you've seen. So I was going to take that course and then come to the law, and then come to my grounds and address it in
Well, I mean, as you say, there were 2 main orders under appeal.
Yes.
There was the 14th of May order, which gave directions for trial and refused the adjournment.
Yes.
And it was in the course of making that order that the judge decided that PD 51Z did not apply to the proceedings. Then there was the substantive order, striking out your client's statement of case and giving judgment for possession, etc., etc. Your appeal was in time for that.
Yes.
Was out of time for the 14th of May.
And the 19th of
It was argued against you that you couldn't appeal the 23rd of June order without first overturning the 14th of May order.
Yes.
The judge decided to park that issue
Yes.
and concentrate on the 14th of May order, applying the Denton principles. There were a number of points that Mr. Dutton took about why PD 51Z did not apply, all of which were rejected by the judge.
Yes.
He decided that there was a serious default, there was no good reason for it, but because he was able to form a clear view of the merits, which one doesn't usually do on a Denton-style application, he said, well, I'm going to allow the appeal, give an extension of time and allow the appeal on terms your clients pay the costs straight away. So we know the shape of the case.
Also, yes. The only matters that I would add to that is to flush out the extent of the argument on the substantive.
Well, it took most of the Friday.
I beg your pardon?
It took most of the Friday.
Well, Lordship, yes, and I do say it's relevant to look at the scope of the arguments. In summary, if one looked at my appeal notice, which was dated the 14th of July, so the one that was in time, that simply addressed the point that the proceedings were subject to the automatic stay. The judge had got it wrong. Very short grounds, very short skeleton argument. Skeleton argument in the bundle dated the 14th of July wasn't quite where matters ended. There was a further skeleton argument which simply made reference to TFS in terms, but apart from that was substantially the same. So that was the only point that we took in terms of the appeal. And then, as your Lordships identified, there was then the Respondent's skeleton argument and Respondent's notice. And your Lordship, my submission is important to note the extent of the issues that were taken in substantive issues, apart from the Denton issues. And your Lordship, if I can just take the court briefly to that. The Respondent's notice, is at 40, divided 14, page 180. To be clear, it's the Respondent's notice before Justice Meade. 14, did you say? Yes, divided 14, page 180. That's where the formal part of the Respondent's notice begins. And the additional reasons are set out in an annex document, which begins at page 127. Different and additional reasons for upholding the order of His Honour Judge Gerald.
I'm wanting just to trace the chronology of the proceedings because the appeal took a long time to come on. You launched it in July and it was heard in May. So as we go through this, could we just identify the time scale as we go through this? So
yes.
You start off with an appellant's notice on the 14th of July.
That is correct.
Your skeleton argument that you have already referred to us to tab 13 and you're now taking us to tab 15, where the Respondent's notice is dated when?
The Respondent's notice is dated the date on the just checking the index.
11th
There on the face of it.
11th of February.
Yes.
Sorry, I've come to 169. So, in terms of the progress,
26th of January 2021.
sorry,
Respondent's notice.
Respondent's notice itself,
26th of January 21.
thank you, and the,
The Respondent's skeleton was the 11th of February 2021.
right, that's tab 15, which you,
Yes.
when you say skeleton, it's described as skeleton and
Yes.
different reasons. It's a composite document.
There are separate documents. There's the Respondent's notice with the annex additional reasons, which are at page, that's at pages 118 to 126.
Yes.
And then there was the skeleton argument which followed that, at page 127 to 169. And I was just going to invite...
In my bundle, the Respondent's notice, tab 14, ends at page 126. And then tab 15 says Respondent's different and additional reasons, which I took to be what you referred to as the annex.
Yes.
If it exists.
And that ends at page 131.
Lordship,
Is it just in the
correct
wrong
document.
tab?
I think it's been put in the wrong tab.
Right.
Yes, I didn't put it, it's in the right tab.
So the skeleton starts at 132.
Correct, Your Lordship.
And sorry, just to get the dates of these.
Your Lordship, I take you to the additional reasons to highlight the 6 principal arguments which the Respondents relied upon for Justice Meade as to why substantively the appeal should not be allowed. And Your Lordship sees that, first of all, they were contesting that the practice direction applied at all, notwithstanding the decision in TFS.
Well, that their first reason wasn't really a reason in front of Mr. Justice Meade, because they say, don't they, in paragraph 3, the extent of the decision in the TFS bars that argument.
Yes.
He reserves his right to go further,
Your Lordship, yes.
and then he goes on to try and either distinguish TFS on the trespasser point, or
Yes.
injunction point,
That's right.
or alternatively to persuade the judge that Judge Gerald lifted the stay.
Well, that's
Or
that's
alternatively,
right.
well, it should be lifted.
Yes, there was the trespass point. Then there was the injunction point.
Yeah.
Then in fact there was a fourth point, which is at page 129, which is that the only part of the proceedings was stayed, so that was also not accounted for. Then the stay was lifted by virtue of the orders that were made by Judge Gerald, and then sixthly, and this is important in my submission. To the extent the judge's exercise of his discretion falls to be reconsidered by this court, the exercise of his power to make the orders under appeal should be upheld. So there was a general discretion point taken, and that feeds into why in the skeleton argument for the respondents before Mr. Justice Meade, they set out all the background. So it was not just directed to the Denton point, but it was also directed to this sixth ground, which was a general discretion that they asserted his Honour Judge Gerald had to make the orders that he did.
So, but just looking at the litigation chronology, although when people have solicitors, the clock never stops ticking, the position is that there was 6 months since you had filed your appellant's notice, in which nothing of any great moment appears to have happened in analytical litigation terms.
I think because of the pandemic.
Yes. Whatever the reason, that we're not looking at that period as a period in which any great costs were being incurred by visible activity. At the point that you're talking about, where we have the 3 documents which you're taking us to now, then there was a massive pushback by the respondents in an attempt to maintain possession of Judge Gerard's order.
Yes.
Effectively, Judge Gerard's last order, which had struck you out.
Yes, that was very much the focus of the respondent's notice and the reasons which we've just looked at. When we come to the, there was no mention of Denton, interestingly, in those additional reasons. We find the first mention of it in Skeleton, so where they start, as it were, focusing on the 14th of May order, and that's how it develops into the linchpin argument, which is
Right.
dealt with.
But just so we have some working sense of this, it rather looks as if the bulk of the costs, with the exception of those incurred in actually drafting the appellant's notice itself, and supporting skeleton argument, which was dated
11th of February.
11th.
The appellants.
The appellants.
On the 14th of July.
Yes, so
many months before.
your hand had been played
Yes.
in July. At that point, there's 6 months, and costs start to be run up again. And so,
Yes.
to a significant extent, the costs, high as they definitely were, of the appeal, are costs that were run up in 2021 rather than in 2020.
Lordship, I think that must be right.
So we're focusing now more narrowly on what happens from the point that the respondent puts up
Yes.
his case.
Yes, as we move towards the hearing.
Right, thank you. That
Starts to
helps
see
me at
exactly.
least to situate
Yes.
the costs position.
Lordship, and how the argument evolved, can then be seen from the skeleton from February 2021, the respondent skeleton, which I was going to take the Lordship to. That is, that begins, as we mentioned, at page 132, and then there's a helpful index to it, and one can see that as far as it addresses the 6 issues, it also starts at this stage to address the application to extend time, and one can see that the extent of the skeleton that covers that issue, the extension of time issue, begins at paragraph 53 and runs through to paragraph 73. So, of course, that's page 100.
Sorry, 53 to 73, do you say?
Well, that's how it's, yes, my lord, that's how it's identified.
Yeah. Well, the respondent's proposal was in the decision tree at paragraphs 13 and following.
Lordship,
And they were saying, well, the first thing you've got to decide is should your clients get an extension of time? And in the end, that's how the judge decided it.
Well, Lordship, he came to that point after addressing the substantive points.
Yeah.
That's in fact how what happened at the hearing. I'll take you Lordship to the transcript to demonstrate that in a few moments. But in terms of the arguments that were engaged in the skeleton argument, your Lordship can see well, it's a very lengthy document, the skeleton argument, running through from pages 132 to 169. So one has 38, well, given the last page almost there, one has 37 pages of skeleton argument.
I'm sorry, Mr. Letman, can I ask you to speak up?
Yes, my lord. 37 pages of skeleton argument.
Yeah.
Of which the application for the extension of time, so covering the Denton, covers pages 18 through, and you'll see it 151, the second stage, and then we get to the third stage of general discretion. That runs through to the top of page 155. So we've got 6 pages of a 37-page skeleton argument at that stage, addressing the extension of time. Well, the response to that comes in April, and that is our supplemental skeleton argument, which was prepared just in advance of the May hearing. And Lord, so far as that is concerned, if I can take you to that, if you have it, do so it may be convenient.
This is what we got this
Yes,
morning. Yep.
it's also in the supplemental bundle. Lord, my copy of that document. Yes. So that is our supplemental skeleton. What that addresses the 6 points, substantive points relating to the appeal, as you can see from the subheadings within the document. The extent to which it deals with the extension of time point is marginal if it's only reference to paragraphs 40 and 41. So this was prepared to deal with the substantive issues in the appeal. Page 12 of the skeleton argument. Our position, of course, was that in principle there was no need to go into the Denton point. Of course, that's not how matters were dealt with at the hearing before Mr. Justice Meade. But our submission is that whether the orders were a nullity or the court could exercise its jurisdiction under Part 3 of the CPR and just say it was an interlocutory order. And therefore, I'm now going to correct the error that was made at the earlier hearing. So, the important point, for present purposes, however, we didn't significantly engage in terms of costs. You can see the extent of the reference there. So very little costs on our side, near to nothing, I would say, costs incurred on our side in relation to the Denton points.
It would be quite a long shot to get the court to reconsider the order under Part 3 when there'd already been so much continuing litigation in the county court without appealing against the order. I mean, normally, if you look at Tibbles and SG, whatever it's called, a lot of water had flowed under the bridge since the judge's order of the 14th of May.
Your Lordship, that may be so, but that's how we attempted to deal with it. In fact, the night, almost the next point issue in the chronology was the night before the hearing. We were sent a copy of an authority which raises the whole issue of issue estoppel, and whether there was an issue estoppel arising on the interlocutory order that had been made on the 14th of May. We said that at the hearing, we then said, well, we can't deal with that because it's a relatively complex point. But you can see reference to it in the transcript. And Mr. Justice Meade accepted that it was a complex point and he wouldn't deal with it. And it's for that reason that he then said, well, we'll park that issue and then I'll decide whether to extend time or not. And if I decide not to extend time, then of course that becomes a live issue. So that's how he dealt with it, or avoided, if you will, the issue estoppel point. But that was, as it were, the next thing that happened in terms of the arguments that were, as it were, lined up between the parties as one approached the hearing.
By that stage, all the costs had been incurred.
Lordship, yes.
Briefs had been delivered.
Yes.
Skeleton arguments had been filed. And so, in terms of expenditure of costs, nothing happened.
Lordship, the costs had been incurred for the hearing, and then we then moved to the hearing. And Your Lordship, what took place at the hearing can be identified from the transcript. And Your Lordship, if I may, I'll attempt to dissect that as expeditiously as I can, to identify what parts related to the extension of time. But one can see from reading it in full that there was a considerable amount of time in terms of the submissions, certainly on our part, in dealing with the 6 substantive points. And in particular, in the end, they rather reduced to the trespasser and injunction. They were certainly the major issues, but none of the other issues were abandoned, apart from slightly late in the day, literally on the 14th of May, the first point that TFS did apply, and therefore the orders were called by subject to appeal, possibly a leapfrog appeal. They were that's a different point, but subject to appeal in relation to TFS. So that was how matters stood as we approached the hearing. Lordship, can I take you to the transcript and attempt to dissect it? Lordship, this is the transcript that begins at page
184?
184.
Yep.
Lordship, yes, of course, we as the appellants began our submissions, and the first issue which is touched upon is the issue of estoppel. And Your Lordship, what we dealt with, almost in order, were the 6 points, 1, 2, 3, 5. An issue. We came back
Which page are you looking at now?
But Your Lordship, perhaps the easiest way to do this would just be to identify where in our submissions we dealt with the extension of time. Your Lordship, that begins at page 226.
226.
In the transcript. Your Lordship, the transcript begins at 184, and we get to page 226, which is the first point at which we address the extension of time, Denton principles. My count is that there are 50 pages of transcripts which are attributable to the appellants before Mr. Justice Meade, and of those,
sorry, 50 pages of
50 pages of transcripts
attributable to what?
To us and our submissions before Mr. Justice Meade.
Right.
Of which the extension of time section begins at 226 and runs through to 237. And within that, my Lord, the reasonable excuse point, which is referenced specifically by the judge in making his cost order, runs from page 228 to 232. So we either have 4, or if one considers the point more broadly, 10 pages of transcript devoted, in terms of our submissions, to the Denton point.
Yeah.
extension of time.
This is because this was an appeal. There were or weren't any additional statements to those which Judge Gerald had had. None at all. I mean, nobody was seeking to bring in any other evidence or running up costs,
No.
going around the world looking for witnesses or anything of that kind.
Sorry for rising. There was a witness statement filed by Mr. Iftikhar Ahmad Malik in support of an application to set aside the strikeout made to the county court, which everyone agreed should be heard only if the appeal was unsuccessful. And that witness statement was before His Honour, Mr. Justice Meade, but wasn't before His Honour Judge Gerald.
And as far as my reading of the transcripts is concerned, I certainly identified that being referred to and referenced in the transcript. Lord,
I was trying to get to what the judge meant when he said that he had the feeling that a lot of time had been spent on the reasonable excuse point and what that added to the cost.
That's what I struggle, and that's the basis of the appeal. One struggles to find where all that time and where all that cost was incurred, because, my Lord, of course, as has already rightly been pointed out, we are now at the hearing. The costs have been incurred. It's difficult in some ways to say that there are any severable costs on our part related to the extension of the time issue.
And they didn't file any evidence themselves on that point.
What should I?
Sorry,
it was all new.
It was your client who had filed a statement which was, as it were, being held back during the appeal. There was no evidence filed on the part of the respondents to this appeal. No, all right.
So there's no cost on our side, I would say, attributable to the extension of time, apart from if one can carve out some of the hearing time associated with the 4 or 10 pages of transcript. I say there's nothing on our side to deal with.
So the evidence about whether there was a good reason was in the 2 so-called statements of truth, was it? Which were before Judge Gerald on the second application to adjourn.
Your Lordship, yes, that's right. That included, I think, some medical certificate or evidence. But Your Lordship, we as I think Mr. Justice Meade points out in the course of submission exchanges with Mr. Dutton, who was leading the learned friend, pointed out that we had barely defended that position in our submissions, and that's right. We hadn't, and he makes the same point in his brief judgment.
Yeah.
Lordship, we didn't feel the need to go into great detail over that, and were circumspect in our defence of that position. So, Lordship, that's how we dealt with it. As far as the respondents are concerned, they addressed the substantive issues, in particular the trespass.
Well, they went into the background in quite a lot of detail.
Your Lordship, they did. Yes. I mean, I accept that. But Your Lordship, I say that, well, they explain, in fact, in the opening paragraph, one of the opening paragraphs of the skeleton, why they're doing that.
Yeah.
And only one of those reasons relates to the dental point. In particular, I would say it related to the 6th ground, which was a broad discretion seeking to justify the decisions that His Honour Judge Gerald had made on that broader 6th ground. So they would have had to do that anyway, we say. I say my submission on that, so they can't wrap those into the costs that they were incurring, if there are any severable costs that they were incurring on the extension of time issue. So, Your Lordship, in terms of their focus on the extension of time issue in the transcript, again, according to my own count, 41 pages of transcript on their part, 14 of which go to the extension of time issue, and I can give you the page references are 264 to 278.
264 to 278.
And the sub-issue, reasonable excuse, is covered at page 267 to 270 of the transcript. So we either have 3 pages or 14 pages of 41 pages of transcripts on their part that records their submission, so reflects the time that was taken and the substantive hearing on that issue, which is no more than 30%, approximately a third.
Yes, but there's the preparation cost as well. And that's what the judge was getting at, I think, because he said it was predictable that it was going to be argued. In the end, it wasn't. But so I read what the judge said in his ruling. He thought that the respondents would have spent quite a lot of money on that issue.
Your Lordship, yes.
Not simply at the hearing.
But in preparation,
Yep.
yes, in reading the documents that related to why we didn't attend. So in terms of preparation time, but whether Your Lordship one can sensibly carve that out and say that there is a hypothecated amount that is referable to just that, Lord, I would say is a difficult question. But yes, if I was to say that one can't really extract the cost of preparation for that issue from the costs of preparing for the appeal, because there are all the other issues in their 38-page skeleton argument. And then when one gets to the hearing itself, again, most of the hearing, certainly 40 pages out of 50 of our transcript, and 27 pages out of 41 of their transcript, are devoted to the other issues, including the issue of stop would have arisen the night before. So, Your Lordship, that's the context in which I say that there was then the argument, or the two arguments about costs that took place post the substantive judgment. Perhaps I ought not to ignore the extent to which the extension of time issue is dealt with in the judgment itself. If I can just take you to that. Beginning at 308.
308, yes.
And although this doesn't relate directly to costs, part of it are it gives some indication of the extent of the arguments and the extent
this is
of
the judge's
arguments.
substantive judgment.
Yes, the substantive judgment, 308. And there's the background section, which I've already referred to. And then the trespass point takes up paragraphs 27 to 46, and the injunction point, paragraphs 47 to 54.
47 to 54.
54 paragraphs.
That's competing noise.
Yes,
This is fine.
also paragraphs 47 to 54. So the majority of the judgment is concerned with the substantive issues, which are succeeded. And then, so far as the extension of time is concerned, we come to paragraphs 62 and 63. So 62 assesses what the serious, whether the breach was serious or significant. 63 then considers whether there was a good reason. So relatively truncated treatment, which reflects the extent of and there's there's the reference to fairly argued by Mr. Jordan at the top of page 320.
Yes.
And then he returns to the question of what would have happened if the the notice of appeal in relation to the 4th of May hearing had been served in time. But that was, of course, directed to considering the extent of the prejudice that had been suffered by the respondent, and then led to the argument about, well, what was the relevant period to compensate for that prejudice. And ultimately, the period was set at the 4th of June until the 14th of July. So the last date for appealing the order of the 14th of May, up until we actually appealed the order of the 23rd of June within time. So, Lordship, that was the context in which he was considering what would have happened. Of course, that's all predicated. It's a slightly virtual world, because it's all predicated on the basis that there had been a notice of appeal in time, if there had been a notice of appeal in time. And that's the loss of chance point which the judge is considering. And then he makes the order that we should pay the cost straight away for that period. He then moves, and that's his ruling, as you, I just can take you to those references, the proceedings after judgment.
That's 66 and 67, isn't it, of the judgment?
Your Lordship, that's right.
Yeah. Incidentally, I'd forgotten, but you did tell us that you got an authority on the estoppel point the day before the hearing, and I see, which I hadn't remembered, from paragraph 58, the point was raised by the judge himself.
Yes.
I must say, I haven't remembered that either. All I remember is receiving the authority and working very hard overnight to get to the bottom of the point.
Yeah.
And, well, as your Lordship will understand, it's a complex point, the extent to which interlocutory orders.
This was in the supplemental bundle, wasn't it? The exchange of emails
Yes.
fell in the supplemental bundle. Yes, 13th of May, 10:28 to the parties from the judge's clerk.
Lordship. Lordship, then of course following the substantive judgment we have the arguments on costs. First of all, the argument about the appropriate period, and that is from page 323 through to the ruling on that, where at 329, first half of that page, period for which the respondents were being compensated for the late service of the notice of appeal is fixed by Mr. Justice Meade.
Could you give me, sorry, 323 to 329?
Yes.
Right, thank you.
Then having decided that issue, there's then the argument separately. There's the argument about the cost of the appeal. So that, running from 329 through to the decision made by the judge, the ruling at the bottom of 332, which is the judgment, of course, that I'm seeking to appeal. Yeah. Lordship, that brings me to my grounds of appeal. Just return to those. I was going to look at them in terms of my skeleton.
Yep.
Which doesn't go very much beyond the actual grounds themselves. Ground one, we say that given the success of the appeal and the many issues on which we did succeed, the 6 issues, the substantive issues, that were the subject of the submissions which I've taken Lordships to, both written and oral, there was no sensible reason for actually depriving us of our costs at a headline level. So,
you didn't ask for your costs below. Mr. Jordan asked for half the costs.
You did, Your Lordship, yes. We made the concession was made.
Yeah.
And Your Lordship.
So if you didn't ask the judge to award you all your costs, how can you say he was wrong not to have done that?
Your Lordship, I don't get that far. Of course, Section 9 of my Appellants notice says what we're seeking is an order that we should recover 50% of our costs. Right. So I accept the concession that we made at that point.
Right, so that's ground one.
Yes. The second ground is that the point that's taken there is that the perhaps runs into the same difficulty as my ground one, because what I'm saying there is that this success on the subordinate point by the respondents, namely that they were successful in establishing that we didn't have any reasonable excuse, which was the limit of their success in relation to the Denton point, that in itself shouldn't justify a reduction in our costs. But
That's not what you're saying, ground two. Ground two is leading to the conclusion, I think, that no order is unjustified, but a partial order might be justified.
Well, Your Lordship, yes.
Don't think, at least I didn't read ground two as saying you should have got all your costs.
Your Lordship, no, it doesn't. Your Lordship is absolutely right. What it says is that there were no grounds for depriving us of all of our costs.
Yeah.
And Your Lordship, that is the point, yes. And then ground three concedes that there may be some ground for making a discounted order. To reflect the fact that the appeal was granted on terms, but the discount couldn't possibly be 100%. Couldn't be less than 50%. And this is the settled point which I make, Lordship. If on the one hand we have not incurred any discernible costs in relation to the argument on Denton, and that is essentially the position, apart from the limited time that was taken up at the hearing on that issue, then there's no part of my costs which fall to be disallowed for that point. One then has to consider, well, what is the scope of the costs that are being incurred by the respondent in relation to that issue? I hope I've been able to demonstrate and establish that the extent of their costs couldn't be more than 20 to 30 to 1/3 of their incurred costs, if those can be separated out at all. So that if one is then applying a discount, making a set-off, on those figures, the lowest I get is about 67% or 70% or thereabouts. As I say, I accept, I'm stuck, if you will, with the concession that was made before Mr. Justice Meade. But on that analysis...
just unpack the maths of that. I mean, it would have been open to the judge to have said,
yes,
using your figures, 30% of the respondent's costs were on the no excuse point, which I think is what you said.
yes.
Therefore, I will not award the appellants their costs of that issue, and I will order the appellants to pay the respondent's costs of that issue. So I deprive the appellants of 60%. Wouldn't he do that?
Well, Your Lordship,
Because that reflects the fact that the appellants are not recovering their costs and have to pay the respondent's costs.
Well, Your Lordship, if there were parity in terms of the costs
Yeah,
on both
if there was-
sides,
if there was
then that
parity.
would be right,
Yeah.
yes. But importantly in this case, as one sees from the development of the arguments and the skeleton arguments, and then the time spent at the hearing, that is not the case. There was no parity between the parties in terms of the costs that were incurred on that issue. So I hope I've been able to demonstrate that on that issue, our costs were marginal.
Yeah.
And therefore, it's only the 30% that comes off. And what the judge has done is just look at it in a moment and say, well, there were some costs on that, and without any analysis, simply made the order that he did, ordering the order as to cost. But I say that when one analyses it in the way that I hope I've been able to do with this court, that goes way beyond discount to zero, goes way beyond the generous ambit of this court will allow in terms of revisiting the discretion of a court below. Simply, you simply can't arrive at a position where I end up with no costs.
Well, the judge thought it was a very unusual set of substantive and procedural circumstances. He was struck by that particular point.
Yes.
But your argument is that that calls for more rather than less analysis of what had actually been going on.
Your Lordship, yes, it does. There were a lot of interesting points, which were the subject of submissions and the subject of the skeleton arguments. And that's where most of the costs were incurred. And I was successful on all of those issues. And therefore, I should, in principle, get my costs, obviously. And then some discount should be applied.
To the extent that you were a defaulter,
yes,
in relation to the conduct of the litigation below, you had taken your stripes for that.
Your Lordship, absolutely, yes. I'd bid for the period that was had already been extracted.
So, if
yes, we paid
and the judge doesn't say this, but if he was motivated by a sense that you'd got yourself into this position, it was tough.
It would be doubly punitive.
Then it would be double accounting to
Your Lordship, yes, absolutely.
to make you pay the costs of arguments that you'd also won.
Exactly. Yes. Which I think in those presenting the argument in that way, I've covered my grounds 4 and 5. Your Lordship. Of course, my learned friend raises in his respondent's notice a number of points. I was going to move to those.
Yes,
It's
fine.
convenient for me to address those at this stage. First point, just turning to the respondent's notice, divided for page 28. The first point he takes is that the proceedings before Meade J might have been avoided entirely but for the failure of the appellants to respond to the order of the 14th of May in time. See paragraph 64 to 65 of the judgment. The appellants had no good reason not to do so and had advanced a justification of their conduct which was full of holes. Now, well, so far as the, this is really the stripes point, I'd already been Your Lordship, so far as the debate of paragraph 64 to 65 is concerned, that is focusing on the extent of the prejudice resulting from what might have happened, the extent of the prejudice resulting from the late service of the notice of appeal. And that leads the judge to the conclusion that I should pay those costs. So I say that the respondents had already been compensated for that point. Moreover,
Yeah.
Lords, I say, if that wasn't right, but further in the alternative, I say that that's a completely false view with respect to that friend of causation. The reason why the costs of the appeal were incurred was that they resisted the appeal. They lost. Second point, which Manfred actually takes in his skeleton argument, is that a lot of work was put in to aid contention that they were justified in not responding to the 14th of May order. I think that's the point that's being made there, is that they put a lot of work into the extension of time issue. Well, Your Lordships, I've already addressed you on that. I say that, well, measured. It can be no more than 30%. The third point they make in their skeleton is that the appeal had been successful on terms, which I think I've already dealt with that point. And then the fourth point, which is the second point in the notice of appeal, was that the hearing was a rolled up hearing. And the arguments before him were directed, Mr. Justice Meade, were directed predominantly to the question of whether the appellants should be granted retrospective extensions of time to appeal the orders of 14th of May and the 19th of June. Well, I say that they weren't predominantly taken up with that. That's a false characterization of the skeleton arguments and the oral arguments. Lordship, I'm conscious that I haven't addressed the law, which I perhaps should do. Your Lordship, so far as the test on appeal is concerned, Your Lordship, I added to the bundle the case of Islam and Ali, and it's just paragraphs 19 and 20, which refer, but Your Lordship is more than familiar with the applicable principles.
Sorry, what did you say?
I'm sure Your Lordship is more than familiar with the applicable principles.
Oh, well, I think we know the general approach to appeals from exercises of discretion, but if there are particular points you want to make them.
Your Lordship, now I'm quite content to accept that I need to establish that the judge's decision goes outside the white habit.
Well, it's about as steeper gradient as any appeal faces,
Your Lordship,
and an appeal
yes.
against the costs.
But if one can see on analysis that the decision was wrong, then in my submission one has climbed that hill.
And Mr. Letman, you were referring to paragraphs 19 and 20 of
Islam and Ali.
Thank you.
Oh, that's what we got today, isn't it?
Your Lordship, that's right, yes.
Yeah. I was interested to see that although this court took the view that Mrs. Ali was the winner,
Yes.
they made no order for costs.
Your Lordship,
See
Yes.
paragraph 26.
Your Lordship, yes. But of course, I mean, that was the argument in that case. Who was the successful party?
Yeah.
The initial order having been made in favour of the husband, who
Yes,
or
well,
in favour of Mr. not husband,
the
Mr.
judge at first, the trial judge, gave judgment for Mr. Islam
Yes.
and ordered
That's
Mrs.
right.
Ali to pay Mr. Islam's costs. But in fact, he got much less than he'd been asking for.
Yes.
This court took the view, see paragraph 23, that Mrs. Ali was the winner,
Yes.
but nonetheless, no order.
Lordship, yes. Well, no doubt correct on the facts of that case, Lordship. So far as the principles applicable to the exercise of discretion by Mr. Justice Meade are concerned, Your Lordship, I'm sure again there's no issue between my learned friend and myself about that. Look, it's CPR 44.2 and the authority which, in my position, most helpfully captures the principles that are applicable to the exercise of that discretion was Welsh and Walsall. That should be. I think numbers have changed now, Lord. There
Yes.
was number 8, it's now number 9 in the bundle, I think. And Your Lordship, it's paragraphs 5 through to 11. That includes
Which tab?
tab 9.
Thank you very much.
It's still at 8 for me.
Yes, I've got it at 8 as well, but not that it matters, we can find
No.
it.
So there's the reference to 44.2, the general rule, and then really a 3-stage process. Who's the winner? Are there any reasons to discount? And then consider the order to be made. That also includes the reference to Fox and Foundation piling, which I included in the bundle. A cautionary word from the Lord Justice Jackson. Unwelcome tendency for first instance courts, and I dare say this court as well, to depart from the starting point too far and too often. Your Lordship, for obvious reasons, I draw the court's attention to that paragraph, which is recited at paragraph 9 of the Welsh and Walsall healthcare. You have Fox and Foundation filing in the bundle as well.
Yeah.
Your Lordship, has also, the court drew our attention to the Adira decision. Your Lordship, again, no doubt a correct decision on its facts. But Your Lordship, the facts, in my submission, are rather different from the current case. As Your Lordship will have seen in that case, the hearing, there was a separate hearing rather than a rolled up hearing. So there was the application to extend time for the respondent's notice was heard separately, and an order was made against the Secretary of State for the cost of that hearing. Noticeably, of course, course, there was no reversal of the cost of the appeal, which was still awarded to the Secretary of State as the successful party.
That was the equivalent of your costs thrown away.
Your Worship, it is, yes.
I was asking. I wasn't.
I
I wasn't saying, but it's analogous to that.
Well, it's analogous to the discount that I say can be applied.
The discount.
Yes.
Well, that was, in a sense, that was Mr. Dutton's point, wasn't it? That had permission to appeal been dealt with separately from substantive appeal, instead of by way of a rolled-up hearing, then he said, Mr. Jordan disputed this, and even if you got your permission, if the fact that the application was opposed would not necessarily lead to you getting your costs of that application. And that is indeed what happened in Idera, that the application for an extension of time for the respondent's notice was opposed, the opposition failed, Master granted the extension but made the Secretary of State pay the cost on an indemnity basis, and this court said, well, that's the right balance.
Well, no doubt it was, and one sees that in that case, because one actually sees that there were other issues in play, of course, from the concurring judgment of Lord Justice McCoo, his paragraph 92. There, the court does not view favourably the type of relaxed approach to the timing of the submissions of respondents' notices that was adopted in this case, in that case, and in this. There seems to be something of a rap over the knuckles. It seems to be the pattern of the Home Secretary. So one could see why they might have, in that case, decided to make that order. With which, I say, I have already been wrapped over the knuckles by the wasted cost provision.
Yeah.
And then one comes to the cost of the appeal, and then you look at all the issues and see how the costs were incurred. And they were incurred on those other issues.
Could I just ask you for a moment about Islam and Ali, in order to understand what was going on with the costs of the appeal in that case? We see at the very end that the appeal was allowed in part. There was no order for costs, but the cost was summarily assessed, which suggests, does it, that this was a legal aid case? I mean, were those the great days when legal aid applied to civil litigation? I'm just wondering what one deduces from the very last sentence of the report.
Those costs must be the cost of the appeal rather than the cost below.
Yes, I think that must be right. I'm not sure what one can deduce about the cost status of the parties. There's no indication
of what the order for costs on appeal was.
As I read it, was the appeal was allowed with costs.
Yes.
So
with costs. Yes, I see. I'm sorry, I misunderstood the point that
they were allowed
made earlier.
Yes, my lord's right.
it was the cost of the trial that were no order.
Yes.
Despite the fact that this court thought that Mrs. Ali was the successful party.
Yes. Thank you.
Yeah.
So there's my submission.
Thank you very much, Mr. Yes, Mr. Kinman.
My lords, my lady. This is a case in which the appellants deliberately disengaged from the court process for a substantial period of time, with serious consequences, without any good reason for doing so, and in breach of their obligations under the CPR. As a consequence, their case was struck out, and while they have successfully appealed that strikeout, they now complain that their decision to disengage from the court process has been held against them, in that they haven't received their costs of the appeal. And in my submission, that's a thoroughly unrealistic complaint. I say that when placed in context and properly unpacked, Mr. Justice Meade's cost order, together with its supporting reasons, is an unimpeachable exercise of judicial discretion and, respectfully, there's no basis on which this court can interfere with it. What I propose to do is very briefly set out the context for Mr. Justice Meade's decision, look at the reasons for his decision, and then address why we say this appeal ought to be dismissed. So far as the context is concerned, when trial was adjourned, part heard in these proceedings on the 29th of January 2020, His Honour Judge Gerald listed a PTR on the 14th of May and a resumption of trial on the 22nd of June. And when he did so with reference to all parties' availability, and in particular that of counsel for Fahim and Rahim, Mr. Pettican, who also appeared for Iftikhar Malik at the resumption of the trial earlier this year. What then happened is the appellants unilaterally decided that they were not going to take part in the PTR or the trial. On the 6th and the 27th of May, they sent emails to the court stating that they could not attend either hearing, but when the court and Stevenson Harwood, my instructing solicitors, sent emails in reply, they claimed they had not received them. They then in June switched to sending faxes to the same effect, but they warned that the fax machine from which they sent the faxes could not receive replies. For reasons which have never been explained, although questions have been asked, they did not offer any telephone number or address at which they could be reached to establish a dialogue, and they did not instruct counsel or solicitors to attend either the PTR or the trial to make representations on their behalf. This despite the fact, as I say, these dates were booked with reference to Mr. Pettican's availability, and throughout the relevant period they had solicitors instructed on their behalf in related High Court proceedings. In these circumstances, the PTR took place in their absence on the 14th of May, when His Honour Judge Gerald directed that the trial should resume as listed on the 22nd of June, and as my Lord Justice Lewison pointed out, ruled that the coronavirus stay didn't apply. And when they didn't attend trial, their claim was struck out. Now, on the appellant's own evidence, which was before Mr. Justice Meade, they only asked Mr. Pettican's clerk to establish the result of the PTR and the trial on the 22nd of June 2020. So that's a month and a half after the PTR, which of course they were well aware of. And this is despite the fact that, again on their own evidence, they actually spoke to Mr. Pettican's clerk on the 18th of June to make sure that the court had received their faxes. So there's no reason to suppose that they could not have contacted Mr. Pettican's clerk at any point after the 14th of May to find out what had happened at the PTR. They did not re-engage with the court process properly until the 14th of July, when they filed their appellant's notice seeking permission to extend time to appeal the order made at the PTR, as well as the order on the 19th of June, and permission to appeal all three orders made on the 14th of May, 19th of June, and 23rd of June. So that's a period of 2 months in which they simply didn't engage, and there's no good reason for them not to have done so. They claim they weren't aware of the orders made and could not establish the position prior to the 26th of June. But my lords and my lady have seen that Mr. Justice Meade expressed his scepticism of those explanations. He regarded them as full of holes and raising more questions than they answered. And in his words, it was absolutely clear that the appellants could have established the result of the PTR with a single phone call. Now, the fact that, as we now know, the proceedings were subject to the coronavirus stay and those hearings should not have gone ahead, in my submission, is no excuse for this behaviour. It was not clear at the time. Prior to the decision in TFS, reasonable views could differ as to whether or not the coronavirus stay applied to possession actions brought by way of Part 20, as is demonstrated by the divergence of views within this court. And in any event, it's never been acceptable to ignore court orders and directions simply because one thinks that they are wrong in law. The appellant should have engaged with the court, at least by appealing the decision made at the PTR within 21 days, which would have been the 4th of June. And their failure to do so, in my submission, and on Mr. Justice Meade's judgment, had serious consequences. there's every reason to think that if they had done so, and done so properly, the trial would have been avoided, and all of the costs associated with this round of appeals could have been avoided.
Sorry, just say that again. If they had appealed promptly,
Yes.
the cost of the trial would have been avoided. I understand that. But then you got the costs thrown away.
We did get the costs thrown away, but Mr. Justice Meade was of the view that there was a good chance, which he could not say was unrealistic, that if Iftikhar had received a proper appeal in time, raising the TFS point or something akin to that, because this would have been before the decision, Iftikhar would have conceded the adjournment.
That seems like a very surprising proposition.
Well,
it's to be supposed that your client would have accepted the assertion that the stay didn't apply at a time before TFS, but the evidence shows that when TFS was decided, even after the law was made clear, your client didn't accept that the stay didn't apply. So how could that possibly run that argument?
My lord, we place tremendous reliance upon our linchpin argument, that in order for the appeal to be successful, they would have to obtain effectively relief from sanctions to appeal the
That's a different point. The point that you were making a moment ago, which I'm having difficulty with, is that your client might have read the grounds of appeal from the order of the 14th of May and thought, those are very good arguments, I think I better agree. And that's unreal, isn't it?
My lord, Mr. Justice Meade accepted that it was a realistic outcome, and of course Mr. Justice Meade had been forcibly marinated in the background of this case and the parties' various actions over time by dint of my skeleton argument. So it was something that Mr. Justice Meade regarded as realistic in paragraph 64 to 65 of his skeleton.
That's judgment. 64 to 65 the judgment.
Yes, sorry, not skeleton.
Yep.
Thank you, my lady. The point I was making to my lord just a moment ago is how things would have been different if they had appealed in time, is that we couldn't have relied upon the linchpin argument.
So you couldn't have put up arguments that were eventually rejected?
They were only rejected, my lord, but we established, Mr. Justice Meade accepted that there was a serious breach of the rules. He accepted that they had significant consequences.
I understand that, but the effect of the judge's order is that you were in a position to run a range of unsuccessful arguments at your expense only.
Yes.
Yes.
I merely tried to say that my lord suggests it's incredible that we would have simply rolled over if an appeal had been made before the 4th of June. And my answer to that, my lord, is our prospects of successfully resisting the appeal would have appeared substantially different if we weren't able to say that they needed relief from sanctions.
In respect of 2 of the 3 orders?
In respect of 2 of the 3 orders, but as I say, my lord, we were placing our hopes for the appeal were predominantly resting upon the argument, which wasn't ruled upon one way or the other, but within the transcript, the judge expressed favourable views upon it, that the appeal against the 14th of May order was necessary in order to attack the 23rd of June order.
Could you just, for my benefit, separate out the linchpin argument, which I think is what you just articulated, and the estoppel argument, which came from the judge? What's the difference between those two?
Well, the judge saw them as 2 slightly different ways of expressing the same
It's really two ways of expressing the same general point.
Exactly. He said at paragraph 59 of his judgment that the shift from impliedly lifting the stay to an estoppel arising because of the decision on the 14th of May wasn't a fundamental change of position. He saw it as, the same thing through a slightly different legal analysis. And of course, it's not only how Iftikhar might have reacted to a properly filed appellant's notice. Mr. Justice Meade recognised as possible, although he thought that this was rather less likely, that His Honour Judge Gerald might have reacted by granting and by adjourning the trial. And I mean, that does, in my submission, receive a certain amount of support from the terms of the judgment of His Honour Judge Gerald on the 23rd of June. If I can invite my lords and my lady to turn to tab 16 in the court bundle.
Yeah.
This is really just to illustrate what was really exercising His Honour Judge Gerald. If I can invite the court to read paragraphs 30, 33, 35 and 38.
Yeah. What do you get out of this?
Well, I'm simply making the point, my lord, that His Honour Judge Gerald recognised at the start of paragraph 38 that it really wouldn't have taken very much at all for him to grant an adjournment. You know, 2020 was a weird time. But what he was concerned that the appellants were essentially taking control of the proceedings by breaking off contact and dictating to the court what had to happen. Now, obviously we're in the realms of hypotheticals here, but had a properly filled out appellant's notice, giving proper evidence of why they couldn't attend, which no doubt would have been contained within the appellant's notice, and contact details being provided, in my submission, there's a good chance that His Honour Judge Gerald would have revised his own order of the 14th of May and adjourned the trial.
But the ground of appeal surely would have been that he was wrong in saying that the practice direction didn't apply.
Well, the appellants in their communications did say the practice direction applied,
Yes.
as it turned out correctly, but they also said we simply can't be there for various reasons.
Well, whether or not they could be there, if the practice direction applied, that was the answer.
Absolutely, my lord. But had they filed an appellant's notice on the 4th of July, June, in my submission, that wouldn't be their only ground. They'd also be saying that it was wholly wrong for the trial to go ahead in circumstances in which they were stuck in Spain and the Middle East.
Yeah, sorry, my lady had a question, I think.
No, it's fine. I was just going to take us back to what Mr. Justice Meade says, which is that it's possible, but it was less likely that Judge Gerald would have granted an adjournment. And surely it's not right to go behind that. He thought there was a possibility.
Absolutely, my lady. And I'm not seeking to go behind.
Enhance.
all I was seeking to do was show that there's some material for the suggestion that it wasn't just Iftikhar that might have reacted to an appellant's notice filed in time by adjourning the trial. Mr. Justice Meade also recognised that His Honour Judge Gerald might have done so too, although, as my lady quite obviously correctly points out, Mr. Justice Meade regarded it as less likely.
What's the consequence? Let's suppose there had been an appeal notice in time against the 14th of May ruling. That would then pitch the parties into an appeal if permission was granted. I mean, they would have come into the shoes of TFS, which obviously nobody was aware was happening in another room. But why would that have led to abatement of cost?
Well, if the trial had been adjourned,
and the adjournment didn't cost very much, in the sense that one side turned up, the other side didn't turn up, and the judge did the work to dismiss the party's claim. But I mean, had they appealed, that would itself have caused cost, would it not? It wasn't going to go, it was just shifting the cost into a different arena.
Well, the possibility that Mr. Justice Meade is contemplating is that a properly filed and in-time appellant's notice would have resulted in an adjournment of the trial.
Yes, but the point that I'm making is that whichever way you come round, you come back to the date, and I quite agree, speaking for myself, the fact that the then respondents took it upon themselves simply to boycott the proceedings is unaccountable, and that's clearly what the Judge Gerald thought and what Mr. Justice Meade thought. But I'm not understanding what costs were run up as a result of that decision.
Well, my lord, once the trial's been adjourned,
yes,
it's hard to see what Iftikhar would have gained by fighting the appeal. I mean, all that's being appealed is the order that the trial go ahead on the 22nd of June.
So it requires a sequence of reasoning whereby they appeal in time, and your client effectively concedes the merit of their appeal, and no costs are really incurred in consequence, and this court allows the appeal, or what?
If there's no point in fighting the appeal, if we've lost the trial date, there would be no point in fighting the appeal, because the order that's being appealed is that the trial should go ahead on the 22nd of June. But of course
So just to unpack the reasoning then, the trial's ordered to go ahead in June, but before that date, a notice of appeal against the 14th of May order is served with grounds. It is that appeal is unlikely to be heard before the trial date. Therefore, Iftikhar agrees to adjourn the trial. Is that the sequence of events?
Yes, my lord. And my lord, this must be the view that Mr. Justice Meade took of the possibilities of what might have happened had the rules been
right. And once the trial date's moved, there's no point in pursuing the appeal any further because it's achieved its objective.
Exactly, my lord. And this principle that the trial may well have been avoided had an appellant's notice been filed in time, that is accepted. That's common ground before this court.
But my lord's point is, what about the cost of the appeal, which is what we're concerned with?
Yes.
And I think you say what I attributed to you, that the appeal would have become academic once the trial date had been moved.
Absolutely, Your Honour. My lord. So in terms of the cost judgment, my learned friend took you to this. It's at page 332 of the core bundle. And it's very brief. What we say is possible to derive, to see in it three elements. First, Mr. Justice Meade says this is a unique cost situation piled on top of a unique substantive situation. And I read that as a reference back to what he said at paragraphs 65 to 67 of his substantive judgment at page 320. If I can just invite the court to read those paragraphs again. So he when he's talking about unique positions, in paragraph 65 to 67, he's identifying two highly unusual factors. The first is that he's in a position to say with certainty that the orders under appeal are wrong. That's in my submission, the unique substantive position. But secondly, he says that there's been a serious breach of the rules and that the prejudice caused by that serious breach is capable of remedy by way of cost orders. And in my submission, that's what he's talking about.
Well, wait a minute. No, he doesn't say that. He says by making the occupiers pay the cost between the 4th and the 23rd of June.
Yes, and then says in paragraph 67, both of these things are capable by adjusting the cost order.
And that you read as meaning the cost of the appeal or just the costs thrown away?
Well, at the moment when he was saying this, he's addressing specifically the costs thrown away. But he's referring back to the uniqueness of the position, the unique cost position and the unique substantive position in his cost judgment. Now, it's all very shorthand, as cost judgments often are. But in my submission, that can fairly be read as saying, I've decided that Iftikhar ought not to be prejudiced by what's flowed from the appellant's breach of the rules. And he's importing that reasoning into his cost judgment. Now, secondly, he goes on to say, the principle that costs should follow the event is a very important one, that the appellants have only been successful on terms. Now, that is echoing submissions made to him by Mr. Dutton, who noted that they've only been successful on terms. In his submissions at pages 329 to 330.
It's 330 really, isn't it?
Yes, yes. So, again, making due allowance for how shorthand cost judgments often are, in my submission, that short phrase can be read as an acceptance of Mr. Dutton's arguments. And finally...
Could you just help us as to at what point in the discourse did paying costs thrown away come in? Was it during the paper preparation or was it during oral argument?
It was during oral argument. It actually came from Mr. Jordan for the appellants. His position was always that it was not the right course to take, but he did say to Mr. Justice Meade, I'm paraphrasing, if you regard there as having been prejudice flowing from my client's breach, then that can be compensated in costs.
So that hadn't been said in skeleton arguments?
No, ma'am.
Which I think we've been taken to. But it was conceded only in oral argument, as a hypothetical.
Exactly. It wasn't conceded. And the third reason given by Mr. Justice Meade is that a lot of money's been spent one way or another on the question of whether or not there was a reasonable excuse. Now, my learned friend's shown that the question of whether or not there was a reasonable excuse didn't feature largely in their written submissions or their oral submissions. But that, of course, doesn't mean that money wasn't spent considering the position. The judge was struck by the costs incurred by the appellants, and he drew the inference from the size of the costs incurred on both sides that costs had been incurred considering whether or not there was a good excuse. That's at page 322 by B.
Three two two.
Sorry, my lord. 332.
332. At B.
Yes.
Yes.
And we know that at least some costs were incurred by the appellants on this issue beyond what's in their written and oral skeletons. Because in their statement of costs in the supplemental bundle, tab 18, page 74, one can see at items 16, 23 and 24 work in relation to a Part 18 request. And that Part 18 request was a request made by my client, basically asking questions about the excuses put forward by Mr. Iftikhar Malik in his witness statement. I mean, we just don't know how much of the rest of the work accounted for in this schedule was related to the reasonable excuse argument. But it's certainly not safe to assume, as my learned friend invites this court to, that it was limited to those brief passages of oral and written argument you've been taken to. So, turning to the grounds of appeal, this is obviously an appeal against an exercise of discretion, which this court deals with every day, I'm sure. And my learned friend's appeal can only succeed if he demonstrates either that the judge erred in principle, or he took an irrelevant factor into account, failed to take a relevant factor into account, or reached a decision which was wholly outside the very generous ambit afforded to first instance judges in the exercises of their discretion. And in my submission, no error of principle has been identified. As my Lord Justice Lewison pointed out, it's been conceded that the general rule should be departed from on the facts of this case. This is an argument as to whether they should receive 0% of their costs or 50% of their costs. And as soon as one's in the realm of arguing whether it's 0% or 50%, that's quintessentially a matter for feel and judgment, which is the role of first instance judges, as opposed to appellate courts.
Could you remind me what costs order Mr. Dutton was arguing for on your behalf?
I'm sorry, my lord.
What costs order was Mr. Dutton arguing for on your behalf?
He suggested no order as to costs.
No order.
Plague on both your houses, he said.
Mm-hmm.
Absolutely, my lord. Reflecting the fact that we did run arguments that were wholly unsuccessful. I mean, we've never suggested that those ought to be paid for by the appellants.
That's at 3:30.
Yes.
Mm-hmm.
Has the judge taken irrelevant factors into account? In my submission, none's been identified. The conduct of the appellants was clearly a relevant factor. I don't think any other factor has been suggested that Mr. Justice Meade took into account, which he shouldn't have done. Did he fail to take into account a relevant factor in my submission? No. He clearly had in mind that the appellants were successful, albeit on terms. So finally, was the decision outside the generous ambit afforded to first instance judges? I mean, not infrequently this court has referred to the test as, was it perverse? And we say no. The appellants disregarded their obligations to the court in a serious and substantial manner. They had no good reason for doing so, and they faced the cost consequences as a result. I say that's an entirely orthodox result, and it's on all fours with the case of Adira, which the clerk to my Lord Justice Lewison directed us to. Now, true it is, in that case, what happened was, as the court has heard, the respondent was ordered to pay the cost of the extension application but receive their cost of the appeal. But in the circumstances of this case, that wouldn't be practical. The merits of the appeal were the overwhelming factor militating in favour of the extension of time. Without examining the merits of the appeal, it would have been impossible to rule upon whether or not time ought to be extended. So rather than separating out in an artificial way the cost of the extension of time and the appeal, instead we have an order which, my submission, achieves broadly the same result on a broad brush basis. No one gets their costs. Unless I can be of any further assistance.
Thank you very much, Mr. Kimber. Yes, Mr. Lepton, do you wish to reply?
Your Lordship, unless there are any points I can assist the court with.
I'm sorry?
Unless there are any points I can assist the court with. I was only going to mention a couple of points.
Yeah.
The first was just the exploration of what would have happened if the appeal notice had been served in time in relation to the May order. As I think I submitted earlier, that was only in the context of exploring the costs that, if that had happened, exploring the costs that were thrown away. That, of course, you can't then get away from the reality that the appeal, of actually what happened, there was an appeal that was predicated or based on the notice of appeal.
Well, I think the way that it's put against you is that if a notice of appeal had been filed in time against the order of the 14th of May, the prospect of getting that appeal heard before the trial date would have been small, with the consequence that the trial date would have been adjourned, and once that had happened, the appeal becomes pretty pointless, because it's achieved its object.
Of course, that goes, it really comes back to my causation point, but that's actually not what happened.
No, it's not what happened, because the trial went ahead, and Iftikhar got the substantive relief that he was after.
Yes.
But if a trial hadn't gone ahead, and say everything was still up in the air, I mean, that's the way it's put against you.
In my submission, that doesn't run. The trial went ahead, and the appeal went ahead, and it was resisted, and that resistance failed. The only other point I was going to mention, my then friend referred to the opening sentence, or the reference to unique circumstances.
Yes.
In my submission, it simply can't bear the weight that the learned friend puts upon it. It was really comment leading on to the consideration
Right.
Your Lordship, beyond that, it's not a case of a plague on both sides of both houses. Your Lordship can see the shape of the appeal and the arguments that succeeded. So, Your Lordship, my suggestion is much more closer to what Lord Jackson said earlier, that why should we be expected to pay the costs of arguments on which we were successful?
Well, you're not being asked to pay the costs of the arguments on which you were successful. You're being told by the judge that you can't receive your costs of those arguments.
Two sides of the same coin.
Yeah.
Your Lordship is
Well,
right to express it
rather
that
different
way.
economically.
Your Lordship, for that reason I seek the 50% order.
Yeah.
Just want to ask one thing, if I may. What's happened to these proceedings generally, now that they've been...
My learned friend knows better than I.
Judgment was handed down last Monday. Iftikhar successful, and the Iftikhar and Rahim's claim was dismissed with indemnity costs.
And who heard that?
His Honour Judge Gerald.
Monday of this week or last week?
Last week.
Thank you.
Well, thank you both very much. We're going to rise for a few minutes. Don't leave the courtroom, please. We'll be back and tell you where we're going from here.
Goodbye.
Big stream, so we all want to set it.
Well, yeah, absolutely.
Yes, Mr. Prescott appeared in the evidence, as it were, earlier on.
Yeah, but not in a way that could possibly. Yeah, it was very much.
How long was the trial? How long did it last?
I mean, if you leave aside all of the various applications that were during the trial, it was probably 2 weeks of submissions.
Was there more? Was there more evidence?
Well, yes, of course, my client had to be cross-examined.
Yes.
When are you going to be? Okay. Yeah. Okay. There's been filed. I have one copy of yours, and we may have spares. Yeah, we've certainly got copies of it. Yeah, you should.
So sensible to bring down copies of these to get lost in the court system.
Just have a look at yours.
You want one of ours and the other side?
So I
Mr. Letton, Mr. Kinman, we have decided to dismiss the appeal with costs. We are not at the moment minded to assess the costs summarily, which are extremely high, but we are minded to order an interim payment of £25,000.
Thank you, my lord.
Reasons will follow in writing. Thank you very much for your arguments.
Will they draft an order? So that they've got the paper?
Yes, would you draft an order, and don't forget the supplemental bundle which needs to be in it. Thank you very much.
All rise.